The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by Evan Bernick of the Center for Judicial Engagement and IJ litigator Renee Flaherty. If you like these podcasts, you may be interested in signing up for the Short Circuit newsletter, a weekly roundup of rulings from all the federal circuits except the Federal Circuit. This week on the show, another Chicago gun case, Missouri's irrational alcohol advertising restrictions, a critical lawn sign, and the implications of West Virginia's concealed carry law on the Fourth Amendment. Renee, kick us off.
So here we have the latest in the saga of Chicago's ongoing attempt to ban its citizens from lawfully possessing and using guns. First they ban guns, then they ban firing ranges, and then in this case, the second Izell case, they try to put really onerous zoning restrictions on firing ranges. You can't have them outside of a manufacturing district or within 500 feet of a school or a church. And they ban minors, anyone under the age of 18, from entering a firing range. And again, the Seventh Circuit says, no, that's not okay. And it's a great opinion. It demands that the government provide an explanation for any kind of restrictions it's going to place on people's Second Amendment rights. But what I find frustrating about this opinion is how the tiers of scrutiny have become such a mess. First of all, there's some kind of heightened scrutiny applies to the Second Amendment, and then you have to see whether or not the regulation touches on the core of the Second Amendment. So you have kind of a two-step process within the three tiers of scrutiny, which I find really confusing.
Yeah, that's absolutely correct. And one of the problems is that Heller itself, which is the leading decision recognizing an individual right to bear arms, dealt with a flat ban and said, essentially, you can't flatly ban something that's in common something that's protected by the Second Amendment and is in common use, but didn't specify a level of scrutiny more generally for courts to deploy in future cases dealing with different kinds of restrictions on different kinds of arms. What's really striking about this case, and Renee has talked a little bit about the history, is just how utterly lacking the government is in this case in terms of any justification for its actions other than a broad appeal to common sense. I mean, you have a situation where, at least in the context of restrictions on minors' access to shooting ranges, the government's own expert testifies that the restrictions are overbroad, and yet the government will come into court and argue with a straight face that this is constitutional.
And I think the Seventh Circuit is doing the best that it can with this, and as evidenced by the fact that it has continually struck down every ever-broadening or ever-narrowing attempt that Chicago has made to restrict its citizens' Second Amendment rights. Right,
and the other thing that you can detect from this opinion is the Seventh Circuit's frustration with what it sees the city doing in this case. This is a city that is essentially deliberately trying to attack a constitutional right because it doesn't like the way the individuals are exercising it, and it's adjusting its tactics as its actions are getting struck down. So to the extent that the city would actually offer something beyond an appeal to common sense, the court is increasingly skeptical because it knows what it's done in the past. It knows that ultimately what it would like to do is just ban these things entirely, and it's using these incremental steps not because it's trying to be reasonably respectful of its citizens' rights, but because it's trying to see what it can get away with. Fortunately, you have an engaged court in this case that does the right thing and makes sure that the city cannot attack a constitutionally protected right.
Well, you have an engaged majority opinion. What are the dissent reason in this case?
Well, the dissent reasoned in this case that, look, all things considered, guns are dangerous. The city can take action to ensure that its citizens are protected in various ways, and it doesn't need to demonstrate to the point of ineluctable certainty that its concerns about public safety are valid in this particular context.
Renee, you mentioned that firing ranges are allowed in manufacturing districts. How many firing ranges are there?
There aren't any firing ranges in Chicago, and I think that the opinion picks up on this and says you have to look at the actual effect of the regulations, which is that only 2% of the city could have firing ranges, and the areas where they were allowed, they're not commercially viable.
Right. So the last time we did this, the city banned all firing ranges from the city limits. Now it's just relegated them to areas where they're not economically viable, and therefore people won't construct them, so you get the same effect. And if you have a permitting scheme that's tied to people's maintaining proficiency with their firearms at ranges, then what you have is the city's ideal, which is as few people can maintain proficiency and therefore legally carry firearms as possible.
The city also mentioned that it wanted to ban firing ranges because of air pollution from firing and because of the threat of firearms might be stolen from these gun ranges. What did the court make of that?
That all sounds like it kind of might make sense. The thing is that the city had absolutely no evidence to back that, and in a few contexts in which they have operable firing ranges within the city for law enforcement and for security guards, there have not been any significant reported thefts. So to the extent that, the city is saying things that kind of make sense, you still need to back that with evidence if you're going to restrict people's constitutional rights, and the city could provide nothing, just naked appeals to common sense.
Well, the dissent seemed to think that there was some evidence for banning kids from firing ranges. She pulled up a bunch of news stories where kids had been injured in firing ranges in different places in the country, or they'd shot someone. Does that bother you?
No, of course it bothers me, and it's a valid concern. But as the city's own expert made a point of in this case, that doesn't justify banning minors entirely from training with weapons, so long as they're under the supervision of their parents at gun ranges. So the question is not whether they have valid concerns, but the breadth of the restriction.
Okay, with that, let's move on to the next case. Evan?
Yeah, so this case comes out of the Eighth Circuit. It involves a series of restrictions on the ability of alcohol manufacturers, wholesalers, distributors, and retailers to advertise their products. Retailers are not allowed to post outside of their establishments specific 2-for-1 specials or going out of business sales. They're allowed to advertise happy hour and ladies' nights, but they're not allowed to post specific prices. If wholesalers or distillers choose to list retailers in their advertisements, they have to list a bunch of affiliated retailers as well. Basically, it's just very nitty-gritty micromanaging of advertising, allegedly with the goal of discouraging dangerous alcohol consumption.
And the court didn't seem to think that these restrictions made any sense, Renee.
That's right. They have exceptions that sort of negate what they were trying to get at here. And first of all, this case was on a motion to dismiss. And so the court makes it clear that they've definitely pled enough to get past that stage. And I think it's really interesting the procedural posture that it was in, because the defendants had moved to dismiss the complaint, but the court didn't dismiss it. And then the plaintiffs moved for summary judgment, and the court sua sponte goes back and dismisses the case.
What does sua sponte mean?
Just on its own, without being asked.
So there are two further points that we could make about this. First, as in the first case, there is this kind of appeal to common sense, in the sense that if you prevent retailers from advertising discounted drinks outside of their establishments, well, therefore, consumers who might be tempted by those drinks will not consume them, and therefore there will be less excessive alcohol consumption. That kind of makes sense until you start breaking it down and you think, as this court thought about, the fact that people are consuming on the basis of this advertising doesn't mean they're necessarily consuming excessively, number one. And number two, to the extent that they have this concern, are their actions narrowly tailored to what they're trying to do, such that we actually think that it's plausible that they're trying to do this? And the court comes to the conclusion that no, they're not. Whatever the government has in mind in this case, it really doesn't have anything to do with protecting people from excessive alcohol consumption.
Evan, in the past we talked about a Seventh Circuit case and Indiana's ban on grocery stores selling chilled beer. They can only sell warm beer, and the Seventh Circuit upheld the ban. How's that different from this case?
Because that's a rational basis case, and this, because it involves commercial speech, is a First Amendment case and gets intermediate scrutiny. In that case, the fact that the regulation wasn't well tailored to whatever public safety, public health-related justification the government might have articulated didn't really matter, because they could have conceived of justifications that would justify the government's actions. Here, you actually have an effort to determine what the government is up to and to actually require the government to tailor its means to its asserted ends in rational ways. In this case, the government wasn't able to do that.
Okay, let's move on to the next case, which comes out of the Sixth Circuit. Renee?
So Wagner versus City of Garfield Heights. It is a sign case in the post-Reed v. Gilbert era. And for those of you who don't know, Reed v. Gilbert is a Supreme Court case that was recently decided, a First Amendment case, that says that if the government is going to make distinctions based on content, that strict scrutiny applies. And there were a bunch of cases that were pending at the time Reed v. Gilbert was decided, and this is one of them from the Sixth Circuit. And it involves a guy who put up a fairly large political sign in his yard criticizing an official. And of course, the official noticed this and said, you know, maybe this sign is probably breaking the sign code and needs to be smaller. And the city had regulations on signs that made pretty straightforward content-based distinctions. Political signs couldn't be a certain size, but other types of signs could be. And so the Supreme Court, the restrictions were upheld by the Sixth Circuit. It got up to the Supreme Court, and they GVR'd it in light of Reed v. Gilbert. And now the Sixth Circuit just pretty much straightforwardly applies that standard and strikes it down. And what was interesting about this case is that the government tried to get it kicked out based on standing. They said, you know, probably looking and seeing that Reed v. Gilbert pretty clearly applies, they said, well, some other regulation has got to make this sign illegal, so there's no redressability and therefore no standing. But the court didn't bite on that.
Yeah, and this case is just really a terrific illustration of why, for lack of a better way of putting it, Reed is obviously right. This is a case that involved a public official who took exception to a sign not because it was aesthetically unpleasing or because it obstructed the roadway or did anything that would constitute a legitimate government interest, but because it criticized this politician in particular. What Reed said is that fundamentally the inquiry when it comes to content-based speech restrictions doesn't focus on demonstrating the intent of a particular individual, but the possibility that something that was designed for a legitimate purpose could be used for an illegitimate purpose because it's so easy to turn content-based speech restrictions into instruments of censorship. So by saying in Reed that so long as a city or a government classifies speech on the basis of content, that triggers strict scrutiny, which most of these sign codes, frankly, can't survive. You get something that is really a bulwark against censorship for individuals.
So the Sixth Circuit originally rules against this guy, then it goes to the Supreme Court, which they GVR'd it. What's that mean?
Grant, vacate, remand. It basically means they're granting the cert petition, they're vacating the opinion below, and remanding to redo it in light of usually some intervening precedent, like in this case, Reed v. Gilbert.
So it's just an order. They didn't actually come out with any reasoning or anything. They just sent it right back and said, redo this.
That's correct.
Right, and the Sixth Circuit redid it. They came to the conclusion that their initial conclusion that the fact that this wasn't designed with censorial intent, the sign code wasn't designed with censorial intent, doesn't insulate it from strict scrutiny. And they applied strict scrutiny, and this wasn't even a close case. It's hard to think of how this could even survive intermediate scrutiny, given that the court concluded that the distinctions between the way that this city was treating different signs made no sense and seemed to be arbitrary.
Okay, so from here on out, if you dislike something your councilman's doing, you can feel totally free to put up a sign as long as it's the same size as any other sign that's legal. Okay, let's move on to the last case, Evan.
Yeah, so this case comes out of the Fourth Circuit, and it's an en banc decision. The Fourth Circuit reheard a case that we actually discussed on the podcast last year involving an individual who was pulled over by the police, subjected to a pat-down, and the pat-down produced a weapon. What happened was the police got a tip from somebody who is living in a neighborhood that's known for a certain amount of drug activity. They saw a guy getting into a car with a gun. The police pulled over the car. It was basically a pretextual stop. There was some traffic violation that they used, but they really wanted to determine whether he had the gun. They asked him to get out of the car. He did. They asked him if he had a weapon. He gave what the officer described as a weird look. The officer patted him down. It produced a weapon. Turns out he's a felon in possession, and in his subsequent trial, he wants to exclude that evidence on the grounds that the evidence was acquired in violation of the Fourth Amendment. A Terry stop, which police officers can perform, it's named after Terry v. Ohio Supreme Court case that endorsed this practice, allows officers to pat down people who they reasonably suspect of being armed and dangerous. His argument was because in West Virginia, it's actually legal to carry concealed weapons. The fact that he was armed didn't make him dangerous and didn't give rise to the Terry stop. It didn't legitimate a Terry stop. The Fourth Circuit in the previous panel decision said, yes, that was a violation of the Fourth Amendment. Now, en banc, the majority comes to the conclusion that no, it wasn't. That because it is intrinsically dangerous to be armed, particularly in the context of a traffic stop, essentially the fact that it is legal to carry concealed weapons in West Virginia isn't really here nor there. You can pat people down consistent with the Fourth Amendment.
So, Renee, there is a concurrence in this case. Tell us about that.
Yes, and the concurrence concurs with the result, but points out that the phrase armed and dangerous, it can mean a lot of things. You can be armed with different things. There are cases that say if you've got an umbrella or a wine bottle that you're armed, and you're not necessarily dangerous with those things. But the concurrence says if you're armed with a firearm, that yes, then the phrase is unitary and you are armed and dangerous with a firearm, but points out the kind of danger and slippery slope.
Yeah, and the dissent just argues that the majority is wrong to conflate being armed with being dangerous, particularly in a state that has acknowledged individuals' rights to carry arms on their person. It points out that the Supreme Court decisions on which the majority rests were decided, Terry was decided, in a context where it was not legal to bear arms in your person, and therefore somebody who was armed could be presumed to be dangerous because they were already doing something unlawful. In this case, that's not the case, and what the dissent points out is that if you essentially hold that the Fourth Amendment does not apply in this context so long as you're exercising your Second Amendment rights, you are being penalized for exercising your Second Amendment rights, and you're also allowing police officers a tremendous amount of discretion to target law-abiding citizens based on the fact that they are exercising something that under West Virginia law, they are perfectly within their rights to do. It lends itself to discriminatory enforcement, and in this particular context, as the dissent points out, you have a dangerous neighborhood. Individuals might arm themselves for entirely legitimate reasons in that dangerous neighborhood, and yet, because of that, we're coming to the conclusion that the Fourth Amendment protects you less based on where you live.
Okay, that concludes the show. Thanks for listening. Until next time, this is John Ross from the Institute for Justice, fully expecting that you will get engaged.